Good morning. The court is going to take up the next case on the court's docket. This is cause number C200039CPS. This is in the interest of Israel Chance Reel II. The case is set for a bench trial today. The trial is being conducted pursuant to emergency orders of the Texas Supreme Court via Zoom video conference. Participating in the trial today on behalf of the department is caseworker Yesenia Ramirez and Regional Attorney Jason Jett. The mother of the child is Patricia Morgan, who was personally served with citation and notice of the suit on June 21st, 2021. And I'll verify in a minute whether Ms. Morgan is on our conference. Christy Manning is her attorney ad litem, and Ms. Manning is participating in the hearing today. The alleged father of the child is Brian Michael Crawford, who was personally served with citation notice of suit January 22nd, 2021, and I'll confirm in a moment whether Mr. Crawford's on our conference. There's an unknown father cited by publication through posting on March 2nd, 2020. Todd Simons has been appointed as the attorney ad litem for the unknown father. The attorney and guardian ad litem for the child is Madeline Smith, and Ms. Smith is participating in the hearing today. All right, I show on my screen, I believe Mr. Crawford is present. Is that right?
Yes, sir.
Okay, good. Thank you. The mother of Patricia Morgan, is she on our conference? Ms. Morgan? Okay. Ms. Manning, do you know if she's on our conference?
Your Honor, I've had absolutely no contact with Ms. Morgan.
Okay, thank you. All right, I show on my screen somebody participating in our conference under the name Ronald's iPhone. If you're on that device, could you identify yourself for the court, please?
Foster parent.
I'm sorry, and what was your name?
Ronald Escamilla.
Okay, thank you very much. And then I also show somebody participating in our conference. There's no name on it. It shows a young lady with a gray shirt and glasses on. If you're on that device, could you please mute your device and identify yourself, please?
Yes, sir. Jessica Escamilla, foster parent.
Okay. Thank you.
Thank you.
All right, so the record will reflect that Ms. Patricia Morgan, the mother of the child, is not currently participating in the trial today. All right, as I indicated, this case is set for a bench trial today. Mr. Jett, is the department ready to proceed at this time?
Yes, Your Honor, we are ready to proceed. I think I need to tell the court that last week, I believe on the 25th, that Mr. Crawford, while at the Tom Green County Jail, supplied a DNA sample in this case to determine whether he was or was not the father of the child subject to this suit. We have not gotten a return on that at this point, but I feel like I should tell the court that there is a test pending. We are, however, ready to proceed.
Ms. Manning, are you ready to proceed?
Not, Your Honor, due to the fact that I've had no contact with Ms. Morgan, and so I can offer no evidence as to her wishes in this case.
All right, and
however, as noted, she has been served.
Okay, thank you. Mr. Simons, do you have a position on being ready to proceed today?
Yeah, I'm not ready, Your Honor. I've just gotten back this week from my father-in-law's funeral, and I haven't had a chance to visit with Mr. Crawford. And it didn't come to my, I didn't realize he was in jail, and I was trying to find him last night. So I need to visit with Mr. Crawford.
Mr. Crawford, the matter that's set today is a bench trial. In that trial, the department has pleadings, or in this case, the department has pleadings on file, which, among other matters, request the court enter final orders relating to the child in this case. Those orders potentially include an order seeking to have the parental rights of Ms. Morgan, and to the extent you have any parental rights to the child, terminated. And Mr. Jett, just for the record, is that the department's proposed relief at this time?
Yes,
That-
Your Honor. Yes, Your Honor.
And the department would be requesting, Child Protective Services would be requesting that the court enter an order terminating any rights you may have to this child, as well as Ms. Morgan, and to appoint the department as managing conservator of the child. I'm assuming for the purposes of the child being subsequently adopted by some third party. Now, whether or not the court would actually enter orders to that effect would depend on the evidence presented at the time of trial in that case. In any litigation, you have a right to retain legal counsel to represent you. My understanding is there is a paternity test pending on you at this point, but you've not been established as the father of the child at this time, and I'm not authorized to appoint an attorney for someone who is not legally determined to be the father. But you would have the right to retain a lawyer if you felt the need for legal advice and wish to have one in this case. If the case were continued from the day for whatever reason and the testing came back and reflected that you were not the father, you would be non-suited and dismissed from the case and no longer involved. On the other hand, if the testing came back and established that you were the father of the child, then you would remain in the case if it continued beyond the day and subject to further proceedings in the action, which could still include a potential termination action as to any rights you may have to the child. As I indicated, we're set for trial today. Do you, what is your position on as it relates to this child? Are you ready to proceed with the trial representing yourself? Do you want time to try to retain counsel? Are you requesting a continuance of the trial pending the outcome of the paternity testing?
I'd like to request a continuance pending the results of the paternity.
All right, Mr. Jett, does the department have a position on that request for continuance?
Judge, as much as we're ready to go forward and get this case taken care of, I think that's a completely logical and request to determine whether the test he's taken is going to make him dad or not. We want to go forward, but we're not going to stand in the way of that. I think that could bring up some appellate issues along the line. And so let's make this as clean as possible. And that probably means we're going to need to be reset. So that's fine, Your Honor. Thank you.
All right, Ms. Smith, do you have a position on the continuance?
I'm unopposed, Your Honor.
And Ms. Manning?
I'm not opposed, Your Honor. I find it appropriate.
Mr. Simon?
I'm in agreement.
Well, I think the current dismissal date in this case, which has already been extended, is August 21st, 2021. Given the fact that we may need some time to get the paternity test results back and determine the status of that. And I think at this point, it appears to me like we would need to, if I'm going to grant a continuance, I would need to extend the dismissal date in this case to allow time for the paternity test results to be received and the parties to then take whatever position they may want to take relating to that. So the court is going to find, pursuant to authority granted by the Texas Supreme Court under emergency orders relating to the COVID-19 pandemic, that extraordinary circumstances exist that necessitate the department remaining as temporary managing conservator of the child, and that continuing the department as temporary managing conservator of the child is in the best interest of the child, and that the court should retain jurisdiction of the suit and extend the dismissal date for the case, vacate the trial that's set today, and reset the trial for a later date. The court will therefore enter orders extending the dismissal date in this case to February 1st, 2022, pursuant to the Texas Supreme Court's emergency orders. I'm going to vacate the trial today, and I'll reset it on a date to be announced. I believe we'll need another permanency hearing prior to likely the reset trial date. So we'll have another permanency hearing set, and hopefully by that time we'll know the outcome of the paternity test on Mr. Crawford. The department has continued as temporary managing servitor, and the child continued in the current placement at this point. Mr. Crawford, the net result of all that means is we're going to put this trial back a little bit to determine if you are in fact determined to be the father of the child. As I indicated before, if you are ruled out, then the department will file a motion in non-suit and dismiss you in the case. You won't be involved in the case further. On the other hand, if you are determined to be the father, you'll remain subject to further proceedings. We'll have another hearing in this case prior to the reset trial date. If you are determined to be the father and are opposed at that point to what the department is requesting in the case, you'll have the authority or option to make a request for a court-appointed lawyer. If the court determines at that time you do not have sufficient assets or income to hire a lawyer on your own, I'll appoint a lawyer for you. Mr. Simons is appointed to represent any unknown father, so technically he does not represent you at this point. He may inquire of you about your circumstances, so I'd ask you to cooperate with him and the other lawyers in the case about that to the extent you can. If you happen to be released from your incarceration prior to the next hearing or trial, it'll be important for you to maintain contact with the department so that you can know how the cases are proceeding, the outcome of your paternity testing, and also future hearing dates in the case as well. I'm going to ask if you'll stand by for a minute. I'm going to ask my court administrator to go ahead and give me some dates just so I can give everybody notice of those before we get off today. So if y'all stand by for just a couple of minutes, I'll get those new dates out to everybody and you'll have them available to you. Ms. Ramirez, do you have any additional information on the whereabouts of Mrs. Morgan at this point that you can relay to Ms. Manning?
No, Your Honor, I do not. When she was released from jail, she did not have contact with me.
Okay, you don't have any phone numbers or other ways to get in contact with her at this point?
No, sir, just her mother, Miss Yell, but she hasn't returned my phone call.
All right, thank you. If you get any information, I'd ask you to make sure Ms. Manning and the other attorneys get that information as well.
Your Honor, could we inquire of Mr. Crawford if he has any locating information for her?
Mr. Crawford, do you happen to know how to get a hold of Miss Morgan at this point?
Unfortunately, being incarcerated, I don't.
Okay, thank you. If you learn of any information, there's a standing order in this case for you to provide that information to the other party. So if you get information, it would assist in the resolution of the case to provide that to him. If y'all stand by for just a second, I'm going to set the permanency hearing on August 24th. Stand by for just a second at 4:30. And I'll set the trial on October 1st at 9 a.m. The dismissal date, as indicated earlier, will be February 1st, 2022. All right. So again, Mr. Crawford, if you're released, try to get maintain contact with Ms. Ramirez in the department so they can, one, know your whereabouts and keep in touch with you about the case. Okay. All right, thank you. Mr. Jett, anything else for today?
No, Your Honor. Thank you.
Anything else from the other attorneys?
No, Your Honor.
Thank you. All right, we'll be adjourned.
Thank you.
Gotcha.